Good morning. We're going to give just a moment to clear the waiting room. Just one moment. We've lost the chairs having connection issues, so give just one moment while the chair of the board reconnects. I'll pause the video for a moment. Good morning, and thank you all for being with us. We'll just give one more moment to clear the waiting room. Folks are still coming in. Good morning. This is the voting hearing of the licensing board for the city of Boston. Today is Thursday, December 12th, 2024. This morning's hearing is being recorded and will be posted to the city of Boston's website. While the public is encouraged to attend, there will be no additional testimony accepted this morning. Begin with the license premise inspection hearing, which occurred on Tuesday, December 10th, 2024. Item number 1, H&H LLC, doing business as Harborside Inn, located at 185 to 187 State Street. Date of the incident, May 18th, 2024. Intoxicated patron in violation of Mass General Laws, Chapter 138, Section 64, and assault and battery patron on employee in violation of Mass General Laws, Chapter 138, Section 64, and Chapter 265, Section 13A.
Thank you, Danny. As far as the two issues before us, I don't think either of them were foreseeable, so I don't see a violation.
I had no violation as well.
I agree.
No violation. Item number 2, Pier 50 LLC, doing business as Committee, located at 50 Northern Ave. Date of the incident, June 9th, 2024. Assault and battery, patron on patron, in violation of Mass General Laws, Chapter 138, Section 64, and Chapter 265, Section 13A. And failure to call 911 in violation of Mass General Laws, Chapter 138, Section 64, and Board's Rule 1.14b.
Taking a look at the assault and battery first, I did review the video. The actual assault and battery did appear to be out of the blue. So for that, I see no violation.
I just hard to say.
Yeah, it appeared so.
I do want to note that failure to call 911 is an issue that I think we shouldn't be dealing with this issue right now. This board issued an advisory in April having to do with the responsibilities of a licensee when it comes to something like this and the need to call 911. The testimony on Tuesday was that they felt like this neighborhood, basically it sounded like they felt like, you know, they shouldn't call the police unless it's something more serious. But as chairman of the board here, I want to remind licensees of their responsibilities to call 911. I would like to note this in their docket that they did not call 911. I don't think it rises to the level of a violation, but I would like to reissue April's advisory to the people that appeared on the board on the hearing on Tuesday. And I want confirmation that they've read it, that they've received it, read it, and they've reviewed it with staff.
Yeah, their explanation that they, maybe it was a miscommunication sounded plausible enough. So I agree that it doesn't, it's not acceptable, but I agree that it doesn't rise to the level of a violation.
Docketing sounds reasonable.
So no violation. We'll docket that they failed to call 911. We'll resend April's advisory and ask them to confirm in writing that they have read and reviewed it with staff. Great. Item number 3, Smith & Walensky, Atlantic Wharf LLC, doing business as Smith & Walensky, located at 290 Congress Street. Date of the incident, June 11th, 2024. assault and battery, employee on employee in violation of Mass General Laws, Chapter 138, Section 64, and Chapter 265, Section 13A.
The staff was very cooperative. I don't believe that this incident was foreseeable. I do not see any violation. Both employees were fired.
I agree. I appreciated their candor and I commend their interpretation of the video because it was clear that that manager was a part of the problem. I did note at the hearing about really the issue here is foreseeability, and I think we talked a lot of licensees about this. The relevant video probably would have been the video inside to see if they kind of were carrying on before it actually came to blows. So I don't know if what I said during the hearing was enough, or should we do correspondence? That would be my only question.
Yeah, I support correspondence for sure.
Yeah, I think correspondence regarding the managerial duty of maintaining composure, de-escalation, making sure that clients and staff are safe are fine.
So no violation, correspondence regarding de-escalation, managerial duty, and also preserving video of what could have been the precursor to the incident. Okay. Item number 4, Lucy Management Group, doing business as Lucy Drink and Dine, located at 120A Huntington Ave. Date of the incident, July 13th, 2024, assault and battery, patron on employee ×2, in violation of Mass General Laws, Chapter 138, Section 64, and Chapter 265, Section 13A.
The testimony at the hearing was that this patron had one drink, and apparently there's video of him not even finishing that drink. The suspect wouldn't leave the hotel bar. I don't believe this incident, in my opinion, was foreseeable. I don't see a violation.
Okay, so this one, the one question that I got to that kind of had me at no violation was their awareness of what might have occurred between the woman and the man trying to near the bathroom. Right, I'm on the right one here, right? This was what ultimately was an indecent assault and battery.
Yes.
Yeah, so they testified that it was a brushing and not a slapping, and the police report was a slapping. So maybe the story kind of got more refined when she was speaking to the police. I'd like correspondence that if they had been informed of an indecent assault and battery initially, then that would have been the time to call the police. And then maybe because this guy carried on for some period of time outside and where some of the assault and batteries happened. And so kind of theoretically, if the police had been called right away, they might have been there and maybe the assault and batteries wouldn't have happened. But I accept their testimony that they weren't fully aware of the allegations. So maybe police shouldn't have been, wouldn't have been called at that moment. So I would just support correspondence as to if they were aware of the allegations as stated in the police report, then that would have been the moment to call the police. That's all.
I definitely agree. There was no foreseeability.
So it sounds like no violation, correspondence reminding them of their duty to call the police had they been aware of the allegations in the police report. Item number 5, Concord Entertainment, Inc., doing business as Bill's Bar, the Lansdowne Pub, located at 9 Lansdowne Street. Date of the incident, July 13th, 2024. Assault and battery, employee on patron, in violation of Mass General Laws, Chapter 138, Section 64, and Chapter 265, Section 13A.
I want to note on the record that the licensee did provide video that showed the assault and battery. Which is what we're trying to get to as a board. I don't want licensees to feel like I want them to submit video to us. I don't want them to feel as if they submit video and there's clear evidence of a violation that perhaps they shouldn't submit the video next time. So that is something I want to note on the record. It goes in a positive way towards the licensee that they were able to preserve and provide the video to the board. That being said, I do see a violation. And I would like, I don't know if they have a history of this, Danny?
Yes, there was a violation for employee on patron with a first warning for an incident that occurred last September, I believe.
Okay, so to me, this is a clear violation. It is a second warning to me, but because the fact that they did share this video, it doesn't mitigate the circumstances in any way, but my vote would be to ask the licensee for confirmation that they've performed de-escalation training with their staff. It's clear to me that the staff here was out of control or acting outside what the training would be for a place like this. But we're not getting feedback from licensees that they have done this type of training. I want to know that when they did the training, who participated in the training, and the type of training that was done. People are coming, we're getting testimony on these hearings that it was a rogue employee. Like, employees should know that they shouldn't be acting like this when they're on duty. And management should be doing everything they can to ensure that staff is properly trained. So those are my thoughts and my comments, that this would be a second warning. And I would want confirmation in writing from Bill's Bar, from the licensee, of the type of training they did and who participated.
So I agree. I would also add on top of that regarding the video, we've kind of dealt with this before, that this place and the coverage of the video. The incident begins, way in the back of the frame. They would have us to believe that the patron was the aggressor and, this was necessary. But the video doesn't show that. If they had better coverage, maybe the video would have shown it. And I'm not inclined to give them the benefit of the doubt with this video, especially considering their recent history. We've had a couple of no violations, but they've kind of been not due to nothing going on, but more due to a lack of evidence. And we did give them the benefit of the doubt. Here, I'm not willing to give them the benefit of the doubt. The initial, grabbing this guy was very aggressive. And like I said, it's not clear that it was necessary. And then right in the middle of the frame, as they're bringing him out, one of the employees strikes him very hard in the chest with the forearm. So I saw it as a clear violation. They provided some video and, some of it was clear, but other parts weren't. If they had better coverage in there, maybe they could have helped themselves even more, but it wasn't there. So I had a very clear violation. Very much agree with the need for de-escalation. I think that there's kind of a pattern here. So I'm very concerned with this licensee. I'm very concerned with the fact that they tried to defend it as well. I kind of don't get that at all. So I'm very concerned with that as well. So going forward, yeah, I have some concerns about this licensee, and I hope they get their act together.
Yeah, there's really nothing to add. I agree with the second warning and the correspondence that would cover de-escalation and camera coverage.
Violation, second warning, correspondence about the coverage of the video, de-escalation, and we are going to request that they perform training and provide confirmation in writing of exactly the details of the training, who was trained, who did the training, what was covered. Is that everything? Great. Thank you. Item number 6, Irish Village Inc. doing business as Irish Village, located at 224 to 226 Market Street in Brighton. Date of the incident, August 26th, 2024. Assault and battery outside premise in violation of Mass General Laws, Chapter 138, Section 64, and Chapter 265, Section 13A.
I want to note that one of the reasons why we scheduled this incident was because the police report said that one of the patrons was extremely intoxicated. The testimony at the hearing from the staff was that, in their professional opinion, he was not extremely intoxicated. This assault and battery was patron on patron. It happened outside the licensed premise. I don't see a violation here.
Yeah, there wasn't enough to find a violation here. Wasn't enough evidence.
Agreed.
No violation. Item number 7, Brood Intentions LLC, doing business as The Fourth Wall, located at 228 Tremont Street. Date of the incident, September 7th, 2024. Assault and battery employee on patron in violation of Mass General Laws, Chapter 138, Section 64, and Chapter 265, Section 13A.
The licensee did provide video that was helpful. In the video, I did see the off-duty employee in the white sweatshirt punch the patron, but what was also telling, or the 17-year-old that never was allowed inside, so he wasn't a patron, but what was also telling was that there was another staff member there watching it. So for those reasons, I see a violation.
I agree. Once again, I would add on that I felt like they weren't forthcoming. I mean, I could be wrong, but I felt like they weren't forthcoming about, the details of it. I mean, the person who was there watching it was on the call and before I asked the question about it, didn't testify to that. In the police report, the off-duty employee claims that he only swung once. He clearly swung twice, so he was, minimizing what he had done. And yeah, there was no intervention, especially closing time. That's very much an expectation that as an employee is outside kind of managing dispersal. So yeah, for all those reasons, I saw a violation.
Yeah, I agree with the violation. I think correspondence about the duty of intervening would be reasonable.
Violation, correspondence about duty to intervene as to the disposition of the violation.
I see that a first warning. I would also like training done with correspondence from the board and then from the licensee confirming when the training was done, who participated in the training, and what that training was.
I agree.
Great. And this is, training on the prior one was de-escalation training. What training on what specifically are you asking for?
This would be de-escalation as well.
Okay.
And what I mean by the type of training, sometimes we receive correspondence where it's literally a sentence, staff was trained in de-escalation. I want to know exactly what kind of training modules or whether it's online or in-person training and who did the training.
Okay. So similar to item number 5, we will request in writing that there is training and that they confirm what type of training, who gave the training, and who was present from staff.
Yes.
How about just anything regarding a security plan for dispersal at closing?
I like that.
I agree.
Security, dispersal, and de-escalation. Great. Item number 8, Castillo Beer, Wine, and Liquors LLC, located at 2371 Washington Street in Roxbury. Date of the incident, July 4th, 2024. License is not posted conspicuously in violation of Mass General Laws, Chapter 138, Section 64. Did not call 911 in violation of Mass General Laws, Chapter 138, Section 64, and Board's Rule 1.14b. And assault and battery patron on patron inside in violation of Mass General Laws, Chapter 138, Section 64, and Chapter 265, Section 13a.
So we did receive pictures that the licenses were posted, and the police officer also noted that she just didn't see them as well. They were up high, whereas they really should be easily accessible to anyone who comes in and does an inspection, but I don't see a violation on that. As far as not calling 911, I would like to send correspondence about their responsibilities, including our April advisory. I don't believe our advisories are being read by management, and management is not communicating that to staff. There is a responsibility here. As far as the assault and battery patron on patron, I wasn't able to get to a violation here, but I do have other issues. We have since received correspondence from the licensee that they've upgraded their video. I want to make it very clear it's not okay in the eyes of the board to say we didn't preserve the video because the police weren't pressing charges. This is a licensed premise. What happens inside a licensed premise is regulated by this board. Should something like this happen where there is questionable blood on the ground and a punch or a stabbing, whatever the case might be, the video would be helpful to the licensee in all cases, it's helpful to the board. There is a responsibility to preserve that video. It's not okay. I'm not going to accept we didn't preserve the video because we didn't think the police were going to press charges in the future. So I do see a responsibility here. It appears that they have upgraded the video and they are going to preserve it. So I want this noted in the file along with the advisory on responsibilities as far as calling the police.
Yeah, I agree with everything. Just I wanted to add again, just factually, it didn't make sense to me that they wouldn't preserve the video based on they knew very early on that there was an allegation that there had been a serious assault there with blood on the ground. And so therefore, if you don't believe that happened and you want to protect yourself, then you would keep the video. Regardless of you didn't believe that the police were pressing charges. So it didn't make sense to me. If they have video in there and it showed that it was a minor incident as they wanted us to believe, I feel like they definitely would have saved it. So I agree that I didn't get to the level of a violation, but I seriously question their choices. So I agree.
Yeah, I think that was an occurrence of misjudgment, poor judgment. The preserving the video is not about notification of the violation or about pressing charges. It's about the incident itself. So.
Do I understand correctly? The vote is for no violation across the board. Okay. In addition to correspondence, resending the April advisory, asking for written confirmation that they have read the advisory, reviewed it with staff, and also noting on the record that the licensee had failed to preserve the video in this case.
Yes.
Item number 9, Harvard Convenience Inc. doing business as Harvard Convenience, located at 157 Brighton Ave in Alston. Date of the incident, May 31st, 2024. Selling and drinking alcohol on premise in violation of Mass General Laws, Chapter 138, Section 64. Casino slot machines and betting on premise in violation of Mass General Laws, Chapter 138, Section 64.
So this is a fairly new licensee who has been open since November 23rd. And this violation happened May 2024, not even a year into them having their license. As far as the selling and drinking alcohol on the premise, I see a violation. There were 8 to 10 people in the back room drinking cans of beer while they were on casino slot machines. So taking them one at a time, the selling and drinking alcohol on the premise, I see a violation.
Yeah, not to mention they were in an area that was not open. Area that shouldn't have been open to the public. So, I mean, yeah, clear violation on that one.
I agree.
I'm going to so I'll continue along these lines here. So my vote for this particular violation, they have no history, but the fact that they haven't even been open a year and they were blatantly violating the law, and it seemed to be known in the area that they were doing this. My vote, given the fact that they don't seem to have even tried to follow the law in the short time they're open, my vote would be for a 10-day suspension.
Are we talking just on the selling and drinking?
Just on selling and drinking. Okay.
Yeah, I mean, there can be no question that that's not allowed on a retail premises. So it's not a little thing. It seems to be a very deliberate act. So I could see, a quick harsh penalty here. I don't know how it's going to, slot in with the next violation, I guess. But
yeah.
For me, they're kind of related in that sense that, this is a choice by the licensee to basically act in an illegal manner.
So would you like to take them together, Commissioner?
It feels like it. Yeah. Because if this was just the one thing and without the other, I don't know if I'd be jumping to 10 days. But it isn't one thing without the other. It was kind of a combined activity back there in the back room,
Yeah, and not to interrupt you, but the reason why I'm not going with our traditional progressive discipline of first violation, second violation, shutting down is given the fact that this, like you said, was open and deliberate and it seemed to be well known. I don't think this was, accidentally someone bought a beer, a six-pack of beer and was standing outside drinking. This was clearly permission given by the licensee to allow this to happen. It was a way they were trying to make money, in my opinion. So to me, this was egregious and, like you had stated, is deserving of a quick and harsh penalty.
Oh, I'm in full agreement. I just kind of saw it as combined situations. So
Yeah.
yeah, like feeling like they're separate doesn't like I said, if this had only been some drinking in a back room without basically running a gambling hall, I don't know if I'd be throwing 10 days at them. So I want to be clear about that for maybe if there's another incident down the road. I very much agree with the idea of like skipping a warning, skipping 1 day because of what was going on here, but I see it more as a combined thing. So that's all I want to be clear about.
Yeah, I think we can talk about things in the totality of the circumstances.
That being said, I would like to propose putting conditions on their license that they can't have any gambling devices on the premise moving forward, and no amusement games as well.
I mean, does it have to be expressed? I mean, but sure, absolutely.
It shouldn't be, but I think it's important to spell these things out because it doesn't seem to be clear with some licensees what they can and can't do.
Yeah. Definitely part of the messages is like they need to review their rules and regulations, and despite the fact that they're new, they do make an affirmative statement as they got the license and as they were getting their manager on duty, that they understand the rules and regulations. That's part of the affirmative statement that they make. So they definitely need to review them.
So Chairman Joyce, you've made statements about the first violation. Do you have anything to say about the second, the casino slot machines, the betting on premise, if we are considering them together or even if we're considering them separately?
Yeah, I see a violation there. Illegal activity happening on a licensed premise.
Yeah, I mean, so that's what I wanted to get to. I saw it as, definitely more likely than not that they were using these machines for gambling purposes. I don't think we had a plausible alternative explanation. The idea that it could have been anything is very much more a criminal defense where the burden of proof is much higher. I think with all the evidence we had, and clearly the evidence we didn't have because of Fifth Amendment issues, once again, I think I said it, but I'll say it again. I did not accept that. I didn't consider that affidavit, no part of it. I didn't accept that she could make some statements and not others, not be fully available to us. A licensee is required to be available to us to answer questions. She has every right to assert her fifth, but we have every right to basically find a negative inference. So for those reasons, in the totality, I had serious questions about them carrying on at all. So I'm clearly on board with something like a 10-day, but what I want to throw out there is, do we really question their fitness to, considering they've just started and probably went into this with intentions of doing this from the very beginning? Do we have any serious questions about their ability, their character?
Commissioner Carney, you just went on mute for a second at the end.
Yeah, I don't know why I went on mute there, but I think do we have any questions about their character and fitness to carry on as a licensee? So that's all I would say. So when I hesitated at 10 days, I wasn't saying that was too much. I just, in the totality, I have serious questions about this licensee.
I think 10 days does reflect a question about their fitness. And I maybe those because all of them happen out of one event or one circumstance, the two violations can run concurrently for those 10 days.
So given the questions that both of you have raised, we would normally perhaps call the manager of record in for a hearing on the character and fitness. I'm not quite sure she'll be able to participate or be willing to participate, but we could request an informational hearing on the character and fitness of the manager of record, if you'd like.
Yes, that actually makes sense. And maybe it's a requirement that the manager of record be changed based on how that hearing turns out.
Yeah, just if we brought them in, maybe we could notify them that we would want some sort of plan of action.
Yeah.
I mean, what I would like is some sort of acknowledgement of something happening first, because they were in denial. And if they're willing to acknowledge it in some way that they can acknowledge it at this moment because of the potential criminal issues, a plan of action to redeem themselves. You know, some sort of assurances to us that they can run this in a legal manner.
So to summarize, it sounds like there's a violation on both counts here that the board is taking together for a 10-day suspension to run concurrently, and additionally, the board would like to call an informational hearing to assess the character and fitness of this manager of record and of this licensee.
Yeah, in total, I don't know how the principles of the corporation are, you know, organized or whatever, but yeah, in total,
yeah,
everyone involved in it, whether it's just this manager of record or
of the licensee and the manager of record. Right.
I support that.
All right. Anything further on this one? Okay. Moving on to the transactional hearing, which occurred yesterday, Wednesday, December 11th, 2024. Item number 1, GTI Properties, Inc., doing business as the Power Station, located at 530 Harrison Ave in Roxbury, has petitioned to change the manager to Gianpaolo Donato Nicosia.
I vote to approve Mr. Nicosia as manager of record. I believe he has the appropriate character and fitness to serve.
I agree.
I agree.
Item number 2, Trinity Stewart Concessions LLC, doing business as the Raffles Hotel, located at 40 Trinity Place, has petitioned to change the manager to Pavel Nadanov.
I vote to approve the change of manager of record. I believe Mr. Nadanov has the appropriate character and fitness to serve.
I agree.
Item 3, JJ Donovan Inc., doing business as Donovan's Tavern, located at 27 Clinton Street, has petitioned to change the manager to Carl Krebs.
I vote to approve Mr. Krebs as manager of record. I believe he has the appropriate character and fitness to serve.
I agree.
Item 4, the 15 LaGrange Street Corporation, doing business as the Glass Slipper, located at 22 LaGrange Street, has petitioned to change the manager to William Bennett Jr.
I vote to approve Mr. Bennett as manager of record. I believe he has the appropriate character and fitness to serve.
I agree.
Items 5, 6, and 7 are the same transaction. Massachusetts Sports Service, Inc., doing business as Legends, as TD Garden, and as Viva Victory Den, all at 100 Legends Way, has petitioned for a change of officers on all 3 licenses.
I vote to approve the change of officers.
I agree.
Item number 8, the Pearl Group at Boston Landing, LLC, doing business as the Pearl, located at 67 to 91 Guest Street in Brighton, has petitioned to pledge the license to Railyard Sports, LLC.
I vote to approve the pledge.
I do as well.
Great.
Items 9 through 14 all also concern the same transaction. Seaport Hospitality, Inc., located at 42 Summer Street. Northern Avenue Hospitality, Inc., doing business as Gather at 75 Northern Ave. Galway, Inc., doing business as The Harp at 85 Causeway Street. Dunboy, Inc., doing business as MJ O'Connor's Irish Pub at 27 Columbus Ave. 150 Canal Street, Inc., located at 150 Canal Street. And Adair, Inc., doing business as Ned Divines, located at 2201 Faneuil Hall Marketplace. Holder of 6 common victular 7-day all alcoholic beverages licenses. I have petition to pledge all 6 to Eastern Bank.
I vote to approve all the pledges.
I do as well.
It is a tongue twister, Danny. I agree.
Thank you very much. Appreciate that. Item number 15, GRNA GRB of MA LLC, doing business as Gordon Ramsay Burger, located at 120 John F. Fitzgerald Surface Road, has petitioned to change the manager to Alondra Rivera, has petitioned for a change of officers, directors, LLC managers, a change of ownership interest, and a change of stock interest.
I vote to approve all the requested changes.
I do as well.
I agree.
Item 16, GRNARK of MA LLC, doing business as Ramsay's Kitchen, located at 776 Boylston Street, has petitioned to change the manager to Adam Christian, has petitioned for a change of officers, directors, LLC managers, a change of ownership interest, and a change of stock interest.
I vote to approve the change in manager of record and the additional changes requested.
I agree.
Item 17, Fogo de Chao Churrascaria Boston LLC, doing business as Fogo de Chao Churrascaria, located at 200 Dartmouth Street, has petitioned to change the manager to Maria Martins Mendez, has petitioned for a change of ownership interest and a change of stock interest.
I vote to approve Ms. Mendez as manager of record. I believe she has the appropriate character and fitness to serve, and I also vote to approve the other requested changes.
I agree.
Agree.
Item number 18, Arjun Inc., doing business as Vine and Barley, located at 326 Sumner Street in East Boston, has petitioned for a change of officers, directors, and a change of stock interest.
I vote to approve the changes requested.
I do as well.
Item number 19, Sophie's Restaurant Group LLC, doing business as Sophia's Grotto, located at 18 Corinth Street in Roslindale, has petitioned to amend the description of the licensed premise to total 1,768 square feet. First floor, main dining room number 1, 2 entrances, exits at 22 rear Birch Street, barred seating for 6, dining room seating 42, kitchen and center, 3 bathrooms located in connected hall. Room number 2, Corinth Street, 2 entrances and exits, with bar seating for 12, seating for 6, 1,281 square foot basement, kitchen prep and storage, annual outdoor dining on private property with seating for 65 from the hours of 12 p.m. to 12 a.m., closing hour 12 a.m.
I vote to approve the amended description.
I agree.
Item 20, Marja Corp., doing business as Giacomo's Ristorante, located at 355 Hanover Street, has petitioned to amend the description of the licensed premise to Restaurant Space A, 355 Hanover Street entrance, in 1 room on ground floor with kitchen and rear and dining area with seating for 25 patrons, storage and kitchen work area in basement and in 1 additional room on 2nd floor with seating for 20 patrons. Restaurant Space B at 351 Hanover Street entrance in 1 additional room on ground floor with additional dining areas with seating for 28 patrons and additional restroom. Restaurant Space A and Restaurant Space B are contiguous and connected through the interior of the premises, altogether comprised of approximately 2,400 square feet, with 2 entrances and 4 exits, 12 o'clock closing hour.
I vote to approve the amended description.
I agree.
Agree.
Item 21, Top Tier Enterprise Inc., doing business as Home Market, located at 165 Belgrade Ave in Roslindale, has petitioned to change the category of the licensed business to a retail package store all alcoholic beverages license.
I want to note that the applicant submitted supplemental materials last night, which were very helpful to me. They went into great detail about the layout of the licensed premise, also what their offerings would be and their inventory, where they will be purchasing their inventory. They noted how their offerings, in their opinion, complement the licensee that's directly across the street, that they plan to be a niche market, not to duplicate what's being offered across the street. So I do believe that they met the elements of public need, and my vote would be to approve this application.
Yeah, I agree. I second everything you said. I vote to approve.
The materials were helpful. Yeah, I agree.
Thank you. Chairman Joyce, would you like the condition on this one, as we have with prior package stores, about the layout not to change without board approval?
Yes, please.
Is there a condition for like nips or singles or?
It was not discussed. They do not currently have that condition as they currently are malt wine only. Anything to say on that, Chairman Joyce or Commissioner Curran?
Yeah, we weren't able, I forgot to put that on the record. We can talk to the licensee about it, but if they don't voluntarily agree, I don't think we can put it on at this point.
So granted, no changes to the floor plan on file or to the amount of floor space dedicated to alcohol without approval by the board, and the floor plan must be on site at all times.
Yes.
Item number 22, Immersive Art Space Boston LLC, located at 130 Columbus Ave, has petitioned to transfer the license and the location to My Izakaya LLC, doing business as My, located at 31 Northern Ave. A Kevin Yufei Liu, manager, 1 a.m. closing hour, and has also petitioned to change the license type to a Section 12 restaurant.
Sorry, this is the Immersive Space Boston.
Correct.
I vote to approve the transfer and to approve the proposed manager of record. I believe he has the appropriate character and fitness to serve. And I vote to approve the change in license type.
I agree.
Agree.
Item number 13, KBG Inc., doing business as Kelleher's Bar and Grill, located at 1410 to 1420 Center Street in Roslindale, has petitioned to transfer the license and the location to Flick International Corp., doing business as Flick, located at 200 Clarendon Street. Corey Templehoff, manager, 12 a.m. closing hour, has petitioned to pledge the license to BPTRS Services LLC. We have been in touch with the applicant and have notified them that they will need to submit a new application and re-advertise to also correct the change of type for a club license. The board cannot vote on it without the correct type, so this will reappear on a later agenda. Items 24, 25, and 26. Treehouse Brewing Company, Inc., doing business as Treehouse Brewing Company, located at 800 Boylston Street, has applied for a 19C Farmer Brewery pouring license, has applied for a 19E Farmer Distillery pouring license, and has applied for a combined 19H Brewery and Distillery pouring license, all to be exercised on the above. Manager Lauren Lanier, closing time 10 p.m.
I vote to approve the changes requested.
I do as well.
Agree.
All three are granted. The remaining items from the transactional agenda yesterday are all new license applications. Chairman Joyce, would you like to deliberate on these or hold until after all of the applications that have been in since December, until December 6th are heard?
I propose deferring all of these.
Deliberation will be deferred. Moving on to non-hearing transactions, the following are applying for a new common victualler license at a previously licensed location. Item 1, Cime Latte Cafe LLC, doing business as coffee shop, located at 197 8th Street in Charlestown. Manager Reina Malara, hours of operation 7 a.m. to 4 p.m.
Vote to approve.
I do as well.
Agree.
Item 2, 242 Cambridge Street LLC, doing business as Honest Taqueria, located at 242 to 246 Cambridge Street. Manager Anthony Ackle, hours of operation 10 a.m. to 11 p.m.
I vote to approve.
I do as well.
Agree.
Item 3, KFA Corporation, doing business as KFA Restaurant, located at 79 Hancock Street in Dorchester. Manager Eliezer Crispin, hours of operation 10 a.m. to 10 p.m.
I vote to approve.
I agree.
Item number 4, Hong Kong Eatery Inc., doing business as Hong Kong Eatery, located at 79 Harrison Ave. Manager Henry Wong, hours of operation 9 a.m. to 10 p.m.
I vote to approve.
I agree.
Agree.
Item 5, Qdoba Company Restaurants LLC, doing business as Qdoba Mexican Eats, located at 101 Causeway Street. Manager Juan Logan, hours of operation 10:30 a.m. to 10 p.m.
Vote to approve.
I agree.
Agree.
Item 6, Honest Taqueria LLC, doing business as Honest Taqueria, located at 359 Huntington Ave. Manager Rob Favuza, hours of operation 10 a.m. to 10 p.m.
I vote to approve.
I agree.
Agree.
Item 7, Senberk Inc., doing business as Istanbul Doner Burrito, located at 417 Washington Street. Manager Bekir Senitz, hours of operation 9 a.m. to 7 p.m.
I vote to approve.
I agree.
I agree.
Item 8, Dig In Boylston Street LLC, doing business as Dig, located at 557 Boylston Street. Manager Richard Cady, hours of operation 11 a.m. to 12 a.m.
I vote to approve.
I agree.
I agree.
Item 9, Siam Bistro Thai Cuisine Inc., doing business as Siam Bistro Thai Cuisine, located at 151 Pearl Street. Manager Adisorn Wiwat Yukon, hours of operation 11 a.m. to 9:30 p.m.
I vote to approve.
I agree.
I agree.
Item 10, Sierra Corporation, doing business as Aurora Market and Bakery, located at 570 Tremont Street in Roxbury. Manager Rabiul Islam, hours of operation 7 a.m. to 10 p.m.
I vote to approve.
I agree.
Agree.
Item 11, La Mesa Market Boston Corp., doing business as La Mesa Market, located at 744 Dudley Street in Dorchester. Manager Leslie Mejia, hours of operation 11 a.m. to 11 p.m.
I vote to approve.
I agree.
I agree.
Item 12, La Cibaena Esa Restaurant, doing business as La Cibaena Esa Restaurant, located at 888A Morton Street in Dorchester. Manager Mary Ladies Cabrera, hours of operation 7 a.m. to 12 a.m.
I vote to approve.
I agree.
Agree.
Item 13, Sauce Boston LLC, doing business as Sauce, located at 33 Union Street. Manager Tanya Walker, hours of operation 11:30 a.m. to 10 p.m.
I vote to approve.
I agree.
Agree.
Item 14, Colo Dorchester Inc., doing business as Yaney's Burger and Social, located at 39 Savin Hill Ave in Dorchester. Manager Fee Pham, hours of operation 9 a.m. to 10 p.m.
I vote to approve.
I agree.
Agree.
And item 15, My Diner Inc., doing business as My Diner, located at 455 East 1st Street in South Boston. Manager Oscar Valle Portillo, hours of operation 6 a.m. to 2 p.m.
I vote to approve.
I agree.
Agree.
Following have applied to make changes to their existing common victular licenses. Item number 1, Chop Corp., doing business as Charlie's House of Pizza, located at 1740 Dorchester Ave in Dorchester, has petitioned to update the capacity from 0 seats to 21 seats based on updated certificates from ISD.
Vote to approve.
I agree.
Agree.
Item 2, Pressed Juicery Inc., doing business as Pressed, located at 148 Brookline Ave, has petitioned to change the manager to Gary Cooperman.
I vote to approve.
I agree.
Item 3, Mahili Inc., doing business as Al's South Street Cafe, located at 179 to 185 Essex Street, has petitioned to change the operating hours to 7 a.m. to 7 p.m.
I vote to approve.
I agree.
I agree.
Item 4, Mahili Inc., doing business as Al's State Street Cafe, located at 114 State Street, has also petitioned to change their operating hours to 7 a.m. to 7 p.m.
Vote to approve.
I agree.
Agree.
Item 5, Mario's Restaurant Corp., doing business as Mario's Subs and Salads, located at 28.5 Warren Street in Roxbury, has petitioned for a change of location to 651 Warren Street in Dorchester, which is also a previously licensed location with a capacity of 0 seats, takeout only.
Vote to approve.
I agree.
Agree.
Following have applied for a one-day amendment to their existing licenses. Item 1, The Catered Affair Inc., doing business as The Catered Affair, located at 700 Boylston Street in the Boston Public Library, has petitioned to amend their license for a later bar closure of 1:30 a.m. for a wedding on January 18th, 2025.
I vote to approve.
I agree.
I agree.
And item 2, AHF Speedway Holdings LLC, doing business as the Charles River Speedway at 1420 to 1440 Soldiers Field Road in Brighton, has applied for a one-day amendment to include the contiguous annex space for a holiday party on December 20th from 5 to 9 p.m.
I vote to approve.
I agree.
I agree.
The board has before them a list of applications for special one-day alcohol beverage applications, which have been administratively reviewed by staff and approved by the board. And on old and new business, item number 1 for a vote, the board had deferred disposition of this violation to allow for the submission of video evidence and supplemental supplementary materials which have been submitted. Big Causeway LLC, doing business as Big Night Live, Studio B and Play, located at 110 Causeway Street. Date of this incident was October 19th, 2024. Assault and battery, patron on police ×2 in violation of Mass General Laws, Chapter 138, Section 64, and Chapter 265, Section 13D. And assault and battery on an EMT in violation of Mass General Laws, Chapter 138, Section 64, and Chapter 265, Section 13D.
Thank you. One of the reasons why I requested a deferral was we wanted additional video, which the licensee did submit to the board and which I did have an opportunity to review. In reviewing that additional video, it appears that the licensee did have a smooth dispersal. What happened between dispersal and the chaos in the street, I am not clear. So I don't see a violation there. However, I would like to request a meeting with the property manager or security team in Big Night to discuss the roles and responsibilities. Testimony was there was no written agreement, but I think there needs to be clear understanding of who's responsible for what and when. And there's also an issue, it doesn't come under this board, but it comes under my responsibilities as executive director on the entertainment side. That a promoter was used here for this particular event, and I want a clearer understanding what Big Night's role is with promoters, what they believe their responsibilities are with promoters. In some cases, we ask licensees to notify the board every time they use a promoter. I don't know if that's the case here, but something went wrong that night. I don't see a clear responsibility on the side of Big Night, but I think there could be more work. There's more work that could be done here as far as cooperation with security and the landlord on dispersal. I'm not sure what that is, but I would like to have a better understanding of that.
Yeah, I totally agree. I mean, really what we need here is clarity because it seemed like they weren't clear on what we expect of them. If they're handing it off to a third party, it doesn't absolve them of ultimately their duty to us and to, the public as far as the sidewalk in front. The one thing I would add is additional clarity on what our expectations are as far as how far it stretches down that sidewalk, towards that parking garage area. That was an issue, and my initial feeling is that we would include that because they had clearly have patrons going towards that parking garage. So I'd like to hear what their plan is and if they have any objections to having that be included. Like if we're gonna, that's my feeling. And so if they have a different interpretation of the law and our rules, I'd like to hear it, and hopefully we can get on the same page on that. So that's all I would add.
Yeah, whatever comes of that meeting, that clarifying meeting, if it could just be in the file in the docket so that we can all see it.
And just to clarify, Chairman Joyce, are you envisioning an informational hearing before the board on this? Is this a meeting with you as chair and executive director of MoCal with the licensee and the security firm? I'd
like to sit down with them and have a meeting about it. I think we could get more done in person and talk through some of the issues that we see, some of the issues that they see dealing with the security and personnel, some of the issues that they see dealing with promoters. This was really serious. The police response was serious. I think they're good operators. I just want to see how we can improve moving forward.
All right. In the meantime, it sounds like no violation on these.
Yep.
Correct. No violation. We'll work to set up a follow-up meeting with the licensee and the security contractor to clarify the relationship and their responsibilities and how far that extends beyond the licensed premise.
Mm-hmm.
Item number 2, the board had deferred this common victular license application. Cantina Hospitality LLC, doing business as Taco Bell, located at 10 Maverick Square in East Boston, has applied for a common victular license to be exercised on the above. Manager Luisa Maria Ospina Villegas Hours of operation 8 a.m. to 2 a.m. And the applicant had agreed to a midnight closing hour inside with a 2 a.m. close for pickup and delivery only.
Thanks, Danny. This is an application for a fast food Mexican restaurant in East Boston. It's located directly across the street from the train station, which I think is a good location for a licensee that has 10 seats. I think this is distinguishable from other Mexican restaurants in this neighborhood that are offering sit-down dining. There's a good amount of their business plan that includes takeout and delivery. The licensee has been working or trying to work with the neighborhood. They've adjusted their hours. I see no issues here. I think it's a good location. My vote would be to approve.
I agree.
I agree.
And finally, item number 3, the board has received correspondence from Food Fiesta Group LLC doing business as Casa Bonita Mexican Grill at 1033 Massachusetts Ave in Roxbury, requesting administrative approval to increase their capacity of the interior from 42 to 142. They've received updated certificates from ISD and fire. No construction has occurred. This was just a change of the interior layout.
Is it correct? It's from 42 to 142?
That is correct. The space was quite empty previously.
Okay, I vote to approve.
Sounds good.
Great.
Thank you all. Those are all of the items before the board this morning. So with that will adjourn this morning's hearing. So thank you all. Enjoy the rest of your day. And if we don't meet again, happy holidays.
Thank you. You too.
Yeah.
Thanks all.